my goal every year with this is to try and find cases and statutes that we can sort of take out of the mundane and out of the law and give it some practical application to what you all are doing on a day-to-day basis, trying to run your businesses and trying to run your HR departments. So we are going to start with the state law update. The state law update starts with the case Brady v. AutoZone. What the Brady v. AutoZone case did is it confirmed the position that the Department of Labor had historically taken, which was that as it relates to lunch breaks, as I'm sure we all know, for non-exempt employees, we're required to give a 30-minute lunch break if they are working over a 5-hour shift. And what the Brady v. AutoZone case confirmed is that we can have our employees waive those lunch breaks if they choose. The lunch break is if the employee is truly off the clock, if they are not on call, if they are not cannot be called back into duty, if they're not doing any actual duties, would be an unpaid lunch break. So the Brady v. AutoZone case confirmed that they can in fact waive these. If you are going to have your employee waive a lunch break or a meal break, it's important that you do so in writing. Have that done so that, if the employee gets terminated, if there's something that happens that's an adverse employment action, that you have a writing where the employee says expressly, I have waived my lunch breaks. The area that was not touched on by the Brady v. AutoZone case, and which the Department of Labor has already taken a position also, is that there is no ability to waive the 10-minute paid breaks that are required every 4 hours. I understand that these can create issues for employees. We've had, for example, we've represented coffee companies that would have at times, one employee working. And how do you deal with these lunch breaks where you can get the waiver, and how do you deal with these with the paid 10-minute breaks? One thing you can do is that these breaks are allowed to be split up into mini breaks, so you can split a 10-minute break into 4 2.5-minute breaks. So there's ways that you can make it a little easier on you as an employer if the position that's being filled is one where you don't just commonly have different people that are available to come in and fill that position. Oftentimes we work with this at a front desk or at a reception job. Having someone who can just come in and fill in for 2 or 3 or 5 minutes at the front desk is a great way to deal with those breaks. So good news that we can confirm that you can now waive those 30-minute meal periods, but just a reminder to do so in writing. A new piece of legislation recently came through from our Washington legislature. It is called the Healthy Starts Act, and as the slide says, it requires employers of 15 or more to provide reasonable accommodation for pregnant employees. What this Healthy Starts Act does is it goes beyond the general obligations that already exist for the Washington Law Against Discrimination or under the ADA. And there are certain things that are just simply required under the law if requested by the pregnant employee. More frequent and longer breaks, seating if job requires to stand, limited lifting, modified food and drink policy. The law is ambiguous and unclear as to what more frequent and longer breaks means. I think that could be an area of problem, but it's all cast under the umbrella of what is reasonable accommodation. So, is it reasonable to give your employee on a 4-hour shift a 3.5-hour break? Probably not. But if they need a 10-minute break every hour, we're getting closer to what would be something that would be reasonable in light of the Healthy Starts Act. The second piece of the Act deals with other reasonable accommodations that may be required. But in these cases, it would require, potentially if the employer asks for it, a certification from a healthcare provider of the employee that these accommodations are necessary. It could be job restructuring, a temporary job transfer, assistance with manual labor, flexible scheduling, and other employee benefits. The kicker to this law is that it does have both a civil penalties side where there's a right of the employee to bring a court case. It provides that jurisdiction. And there's also a right for a complaint to be filed with the Attorney General's office that can result in civil penalties. So this is something that needs to be taken seriously. It's applicable across the state. It's in application now. So it is something that if isn't in practice and isn't in your employee manuals as benefits that you provide, is something that we should assist you with working through. Sort of a hybrid that focuses both on state and federal law. This is the protection of trade secrets. A lot of our high-tech employees and a lot of our employees that have a large customer base are often dealing with issues related to protection of trade secrets. This has become a somewhat hot-button issue in our jurisdiction because of a couple cases related to the commercial brokerage industry. The one I'm highlighting here is the CBRE versus Rice case. In that matter, which is currently being handled in our federal court, the leaving employees from CBRE to commercial brokers were accused of downloading 42,000 documents and taking 1,000 the contact information for 1,000 of CBRE's best customers, clients, contacts. There has now been some litigation to it. The federal judge ordered that the employees that departed provide their devices, provide their laptops, provide their phones to determine what in fact was transferred and to determine whether the things that were transferred were in fact trade secrets. There's also, as part of the end of the Obama administration, the Defense of Trade Secrets Act was passed on the federal level, and this is intended to do some of the same things that our own Washington State Trade Secrets Act does. It would protect employers from misappropriation of valuable information, provides for prejudgment seizure, and provides a whistleblower immunity. And those last two ones are interesting and goes beyond what our state law provides. So the prejudgment seizure would be in a case where someone takes a trade secret and uses that trade secret for their benefit in a very tangible way. So for example, if we take that CBRE case, if the defendants in that case have been able to use the contact list to generate, a sale of real property or leasing, and there was a broker commission in escrow, the Defense of Trade Secrets Act could potentially provide a ability to latch onto those funds and to hold those funds in the court registry until there was an actual determination as to whether there was in fact a misappropriation of trade secrets. From a employer point of view, the whistleblower immunity is always interesting to deal with because what it provides is it allows immunity from prosecution or from liability of someone who comes forward and blows the whistle on someone else who has violated the Defense of Trade Secrets Act. Where this comes into play for employers is if they've hired someone and that person has brought over trade secrets, whether the employer knows of it or not, and is using those trade secrets, and so a whistleblower says, this isn't right, and blows the whistle on them, that whistleblower would be immune. The potential for the employer to have liability and the potential for the new employee to have liability would both exist. A couple things from a practical standpoint to focus on in terms of how to impact your jobs and your employers related to trade secrets. It's really important to have procedures in place for hiring in terms of asking questions about whether there are restrictions in place, non-compete restrictions, confidentiality restrictions. I mean, trade secrets often overlaps with confidential and proprietary data that are protected by employment agreements. So understanding the scope of those, understanding the position that you're hiring for. Are you hiring for a position where trade secrets may be relevant, where a customer list or a contact list is something that could be important and be used. If what we're doing is putting in place hiring procedures that ask these questions, then you as employers are creating some level of insulation from liability for an unknown employee who then brought over this information and is trying to use it. And you can't protect yourself from every situation, but that would be on the front end of things to think about. If you have an employee that is leaving, having that post-employment termination checklist is also important. So on the way out, directly asking, the employee, are they, what are they in possession of that is, the rights of property of the employer. Having in your employment agreement a requirement that they return everything that is the property of the employer. Having a definition of the property of the employer that's very broad, that would encompass everything that could be included as a trade secret. And then also having a process in place by which you can check their computer systems. You can check, I think it's part of what Drew talked about with his BYOD policy, that you can check those devices, that you can determine whether or not there were things that were relevant to your work that was taken. Moving to the federal law update, I think we all hopefully heard about this. There was much hullabaloo last year about the Obama administration changing the rules for the salary test for exempt employees, doubling it from 23,000 to 47,000. A Texas district court ruled against this, ruled that they rejected the rule. They indicated that as it relates to exempt and non-exempt employees, what we are focusing on is the duties of employees rather than the salary. I use this just as a reminder that if you do have employees that you are putting in the category of exempt, think about whether they do in fact apply to one of the executive professional administrative tests. Oftentimes we have employers that come to us and say, well, they're exempt because I pay them a salary. That's not the exempt test. And if you've been at this seminar before, we've harped on that. But think about who are the employees that you consider exempt from minimum wage requirements, from overtime requirements, and think about whether they are in fact meeting the tests, although this makes it a little easier on employers by lowering or at least keeping in place the salary test. Now we're going to get into a couple of interesting cases. The last two cases I will talk about. And they're interesting because they don't necessarily deal with employee interaction with the other employees, but they deal with employee interaction with either the public or people that, I guess, the public or customers or people that come into the business. And that's a little bit different of an analysis than just the normal how are our employees interacting and what are they doing. The first case is Felix versus the Wisconsin Department of Transit. The employee was working for the DMV. She had a part-time desk job, and the other half the time she was giving driving tests to 16-year-old kids trying to get their driver's license. There was an episode at work. There was a number of episodes at work, and she clearly had a disability. She had PTSD, depression, anxiety, and OCD. So there was, obviously some disability implications that were applicable to Ms. Felix's work. She would have anxiety attacks where she would need to use just go to the bathroom and do some breathing exercises. At one point, she had an anxiety attack that led to her screaming in the bathroom. That could be heard from the public area. She then came out of the public area, ended up on the floor, with a dull instrument attempted to slit her wrist, and had stated some suicidal things when she was there. The employer had an independent medical exam conducted of her, in which the independent medical examiner determined that these were not things that wouldn't happen again, that there was a substantial likelihood of these happening again. And ultimately, they terminated her based on the independent medical exam, and she sued. The court ruled that they were justified in terminating her because of the substantial risk that she presented to the public, and in part because of her role in interfacing with the public. So it's important when we're doing these analysis to figure out what is the role that our employee is doing, and are they really interfacing with the public and impacting the public, so that this risk that we're talking about actually presents a risk to them. The same risk could be true internally. So I mean, it's also a safety risk if they're presenting themselves as a risk to other employees. But that I thought that was important to understand, because we advise you to be very careful in the area of disability discrimination, and for just reason, because the laws are really tight there. But it was good to see a carve out when what we're talking about is something that actually presents some level of potential harm to other employees and customers. The other case that deals with the customer issue was the EEOC versus Costco case. This is an Illinois case that's now on appeal. And in this case, it was a Costco employee that was continually being harassed and stalked by a Costco customer. Costco did what you would expect them to do. They warned the customer, they told him not to return to the store, and they ultimately barred him from all stores. But he continued. Their efforts were not sufficient. She ultimately quit working there and filed a hostile work environment claim under Title VII of the Civil Rights Act, and a jury ruled in her favor, awarding her $250,000 in emotional distress damages. I don't think there is a strict legal rule that comes from this case, but what it did highlight for me was it really is important to also think about the impact that your customers can have on your employees, and how you take the process to protect your employees from things that customers may do. We so commonly talk about employment law in terms of a supervisor and their employees, managers, how employees interact with each other. This really highlighted for me the importance of having procedures in place and policies in place for how you deal with your employees that come to you with complaints about being harassed by your customers. I mean, your customers are what makes your business go. It's what pays you. What brings in revenue. So there's obviously a relationship there that you need to work on, but it's important for you also to have a policy in place as to how to protect your employees when those customers are out of line, and that's what this case really hammered home for me.